And a very hearty welcome to all of you who've joined us this afternoon for the session. To start with, let's understand, and the session is centered around IP and data protection. What is an IPR, and what is it that we really mean when we use the term intellectual property rights? So intellectual property rights are essentially the rights given to persons over the creation of their minds. They usually give the creator an exclusive right over the use of his or her creation for a certain period of time. And needless to say, it has been a key wealth driver in the present international trade scenario. Tying it up with why is it important for startups and why IPR is considered to be an important reason behind the success of the Indian startup ecosystem. A startup is, as we all know, is essentially a disruptor. It disrupts an existing market by either providing a more convenient service or a service at a lower cost, or perhaps both. Every startup that enters a market essentially believes that it has a unique strategy. And at the heart of every startup strategy is usually a technology, a clever name, or an attractive logo to support and back them up. The surest way a startup can succeed against larger rivals is by creating and protecting your own intellectual property. For instance, if you see a startup who has patented its ideas or its inventions, the valuation increases and it is likely to attract more investors. Why so? Because investors are more likely to acquire a startup whose patents, designs, and trademarks are all well protected. So unless you protect them using your intellectual property, your rivals, have an edge to copy them and obviously steal your market share around it. Once copied, it will make it difficult for you to, benefit from it, considering you're the originator of the same. Hence, technology is and will continue to be at the crux of the startup model, unless you are, unless protected, can also lead to a disaster situation. Now, besides IP, startups today are aggressively trying to access the global markets by using innovative technologies. One of the primary uses of such technologies is essentially to harness and analyze data of the users. Now, the data is then used to either efficiently target users by offering them relevant products or services, or you're using or saving the data of the employees that you gather. So along with an understanding of the importance of the use of technology and data for your business advancement, you have to understand how important is the analysis around the laws which require you to protect the data and the privacy laws around it. In this context, we thought it would be worthwhile to take a look at some of the data protection and the privacy related legal requirements under the present Indian laws and the upcoming ones in order to be future ready for the same. So we have with us an exciting panel with UniCreate, as a special guest, who's a startup which offers a B2B solution helping enterprises extract data from unstructured documents. To put it simply, document in and data out. So we have Rakesh and Kiran, from UniCreate, and I'll be opening the panel with Kiran and Rakesh on that. So, Kiran and Rakesh, we would invite you to share your experience as startup founders on how you see, processing data and managing IP in terms of your business.
Hi, this is Kiran here. I'm a co-founder and CTO of UniCreate. I handle architecture, design, solutioning, and data science. Rakesh is my other co-founder, who's actually the CEO. I'll let him introduce himself and then.
Hi guys, I'm Rakesh Srivastava, Chief Operating Officer. I'm one of the co-founders of UniCreate. I handle cloud security and development. To you, Kiran, and then we'll take it.
So with the kind of product that we are building, we are definitely having a lot of IP both on our side and on our client side, and it's been a challenge to protect both sides because the system actually integrates both of these. What we bring from our side is the technology side of it, the learning that we have created, the learning system that we have created, and the way it has been put together so that the business can then manage its IP, which is the business expertise of the domain experts. So the product is designed so that they don't need our assistance in order to manage their own data. So essentially, the UI helps them automatically train the system without needing a technical team. And this is one of the challenges that they generally face, that a lot of the businesses do not want to expose their data, even for training purpose, to the software vendors. And that's why we built a system wherein all this can be handled by the business users themselves. So from our end, we do not have access to or knowledge of the data that our clients are actually working with. The system is deployed on their premises or on cloud, and pretty much everything that they put into the system is only accessible to them.
So to just sum up all the challenges which we face in this period was key was who's the data ownership? Who owns the data? Whether it is at the input side or the output side. The second is we don't have visibility to the kind of data which is coming into our system. What happens to the AI and ML generated contents? Who owns it? Who has the right to own it? And last but not the least was the active learning system itself. So once the system is learning, the client would not like to share the models which they have built based on their business knowledge. So the challenges were of 4 different areas. First was on the data ownership itself, the kind of data which is coming into the system, after processing it's going out. And also the challenges, very peculiar challenges which we faced was on low visibility to the data at all. What kind of data will be pushed into our system, and what kind of data will be extracted. The third will be AI and ML generated contents. Who owns it? Where does the IP lies with whom? And the fourth one would be active learning system. So whatever we are or the system is learning based on the data which is coming into the system can't be shared across, either across use case or across clients. So these were the 4 typical challenges which we faced. And we were able to solve all 4 using some very intelligent architecture and design, which Kiran can brief.
Yeah, so primarily we have segregated the learning systems into 2 parts. The part that comes from us, which is all pre-encrypted models that are deployed on the system. And the other part is the models which are created based on the client's interaction with our system. So there is physical and logical separation between all of these. Whatever the client is doing is stored separately and managed separately, and we do not have access to that. Our deployment itself is done on a separate VM so that that is also protected. And the architecture basically makes sure that data, when it moves between these 2, is encrypted end to end, and that neither side has access to the other side.
So typically on the security side, if you look at, there are 3 different layers where you need to secure your data. First is itself is your data. The second, I guess, would be your infrastructure. And the third is the data itself. Whether data is at rest or in motion, that needs to be secured. And infrastructure-wise, you can actually implement security at different layers, whether it is at a network level, firewall level. What is very important for any developers to understand is the security by design for any kind of web app is very, very simple. So whenever you are developing any kind of web app, you need to have an eye on which are the critical functions which can be compromised, since web app is the interface through which your users will be interacting. So have an eye on your CVE database, follow up VASP guidelines to ensure that your web app is secured enough and cannot be compromised if you are following certain guidelines.
Okay, so that was helpful, and I think to give an audience a flavor of how you guys are managing it on ground. Jaideep, over to you for because to continue to the data thread. Privacy has been becoming a non-negotiable act today. So what considerations should a startup really have in mind when they are managing their data and specifically in line of the privacy laws, etc.?
Sure. Thanks, Harshita, and thanks everyone for joining us. In case the audio or video is not clear at any point, feel free to interject and we'll try and resolve it. So I think the first question that a startup should consider, and the background by Unicreate was helpful, is on what kind of data do you process. The way we would generally look at it is, do you process personal data? And within personal data, which is really any data which is capable of identifying an individual person, do you process certain kinds of data which are considered sensitive personal data? And some of the common categories of these are password, healthcare, and financial data. And there are a few other categories as well, like biometric data, physiological information, etc. But probably three of the most salient items which a lot of startups may end up processing is passwords, financial data, and healthcare data. Now, as soon as you process either personal data or sensitive personal data, one has to look at their compliance obligations under the Information Technology Act, which is the primary law governing in India today. So the Information Technology Act has certain provisions on both personal data and sensitive personal data. But as soon as you cross the threshold into sensitive personal data, that's where the compliance obligations kick in. And I'm sure a lot of you may already have some processes in place. But just to recap, as soon as you have sensitive personal data, that is either you collect it or process it, one needs to be mindful of the compliance obligations that trigger. The most relevant ones are that you need to have a privacy policy which needs to fulfill certain conditions. For example, you need to mention the name of a grievance officer whom people can contact. And most importantly, you need to take express consent to that privacy policy. That's something that sometimes is missed out because a startup may feel that I have uploaded the privacy policy on my website and it's there, people can go if they want to. But what the rules really require is that express consent is taken to those policy. And as a matter of Indian law as well, the status of so-called browse wrap agreements is unclear. That is where the agreement or the terms are there on the website, but there is no express consent. It's not clear whether that is legally binding. What is quite clear is that when a user clicks I agree or I accept, of course, the term should be clear and conspicuous. That's one of the conditions of a privacy policy. But that I agree or I accept is pretty much non-negotiable. So that's something that startups should keep in mind. But the first step to really doing an assessment, and obviously you can get detailed legal counsel on this once you do that assessment, is that you need to be clear on what data do you collect, so that you can tell your advisors accordingly. Secondly, you might need to check whose data is it. If you're a B2C company, you would have, for instance, data of your customers. You may have some vendor data, and you may have employee data. One thing that most startups miss that we see in due diligence is that uh, employee data is not treated at par with customer data as far as data protection is concerned. So employees are not made to consent to the privacy policy. But what the law says as of now is that the two types of data should be treated the same, because employee data is personal data as well. And you would generally have things like bank account information and possibly even passwords of employees. So that amounts to sensitive personal data, which in turn triggers the obligations under the Information Technology Act. The other types of situations that could arise is you're a B2B entity and you're processing your customers' customer data. That is, your enterprise customer may have data of certain individuals, and somehow you're processing that data. So to that extent, you have a little diluted requirements as far as collection obligations go, because you're not the direct collector of the data, but you still need to follow other requirements under the data protection. Probably the most significant one is that the restriction on transfer to other entities or outside India without proper consent, and the reasonable security standards which the data protection rules prescribe. Now, this is something that applies across the board to anyone that processes sensitive personal data. They need to put in place a comprehensive information security program. Now, one of the standards which are prescribed is ISO 27001, which is an information security standard. So that is considered a deemed compliance of that requirement. But even other standards which one can defend as being reasonable security practices, and there's no fixed definition of that term, uh, could be alternative possibilities for startups to consider when they implement these programs. If you're a foreign startup, I think the audience here is largely Indian, so I'll keep the discussion on that minimal. But if you're a foreign startup, there is an argument to be taken that the data protection rules do not apply to a foreign entity. The position on that is a little gray, but the ministry had issued a press release stating that the rules apply to Indian entities. So one can take an argument on that, but likely whichever jurisdiction you're in would require basic compliance like privacy policy, etc. in any case. So that's something that you would be well advised to do. And we will come to the detailed obligations of the proposed law soon. I know many of you may be keeping an eye on the Personal Data Protection Bill, which is a comprehensive new data protection law, but we'll discuss that subsequently. Over to you, Rashid.
Thank you, Jaideep. That was helpful to for the clients, for the audience to understand on the basics around privacy. Over to you from here, Aaron. So I think to start with, we have an excellent question from the audience on what type of assets or materials or information really qualifies for IP protection, whether it is logo, name, codes, processes. Let's just to start from this question, and my question to you is that startups today are predominantly IP driven. So after you answer this question, if you could help the audience in terms of what kind of issues do you commonly see that the startups are facing, when it comes to intellectual property protection?
Thank you, Harshita. Could you confirm if I'm audible, please?
Yes, you are.
Okay, thank you. So to start with, and I know some of the participants have asked a question already on, first of all, what can be protected, what cannot be protected in terms of IP. And coupled with the fact that you said today companies, startups are IP rich, and IP forms a very big asset within the company. Now, you have different forms of IP, and I'll start with what can actually be protected. What are the different forms of IP today, right? So you have your trademark. So Harshita at the introduction spoke about a brand name, a logo, right, or a catchphrase that you use, a tagline. These are visuals in the form of words or in the form of logos, which help identify a particular company and the service or the product offering of the company, right? This by itself is independently protected as a trademark. Separately, you also have patents. Patents, I don't want to spend too much time on because I understand most of the audience may be more into software and other forms of IP, but patents are also a type of IP, which is registrable if it is a novel invention, if it has utility, if it has use, and meet certain other criteria, you can also register a patent. One particular point to note is that merely registering software as a patent in India is not possible. Software and computer programs and computer codes are protected under copyright. Now, coming to copyright is one of them, as I said, is a computer. You can do as a computer program software. Separately, you have musical works, you have artistic works, you have dramatical works, you have sound recordings, you have artistic work. So you have different kinds of copyright. Now, what all does this entail? This entails writings, documents, code, software. For those of you all in media, it includes video clips, audio video clips, and the like. So copyright really is a very wide variety. You also have some other forms of IP like designs and semiconductors and all, which we won't get into too much detail because of time constraints. But these, patent, copyright, trademark are your primary forms of IP protection in India. Now, what are the issues sometimes that we face when working with startups? Now, a lot of the time we find that at the first juncture, there's a lot of IP being created by startups. Um, and this is in various forms and modes, right? Like how we discussed, there's coding or there's creation of content, um, marketing, data creation, data analytics. All of this are forms of IP which is being created in some way or the other, right? Along with this, creating goodwill for the company's brand also. Now, the first issue that we find really is that companies, at least startups, when we work with them, is that they're unable to identify what is their IP. They're unable to pinpoint on what is their IP and hence what forms an asset of the company, right? So I think at the first juncture, it's important to have a checklist to keep an eye on what is being created. What are the various brands of the startup? What are the logos being used? What are the programs being created, or what content is being created? Separately, is there any IP being created on emails by employees? Is there any IP being created separately through contracts, through commission works? It's important to understand and to keep an inventory of sorts of what is the IP which is being created. The second part now in IP is that there are various parties involved in the creation of IP, right? You have an inventor. IP can be created by an inventor basically, but that person can be an employee of the company. It can be the promoter or founder of the company. It can be um, a third party consultant or a third party service provider engaged by the startup, or it can be a joint effort or a joint ownership, right? So it's important to know this, because later on, from a title perspective, from a diligence perspective, from an investment perspective, and seeing where the value lies in the company, right? It is important to know that ownership of the IP actually vests with the company, right? And I'll come to this in a bit, but ownership in the company is very important, and not particularly a promoter or a founder or an employee. Um, Now, I want to spend a minute on documentation. Now, we find startups, uh, for various reasons, often sign contracts with customers, especially, right? Given time constraints, a lack of legal review sometimes, and all. These contracts often create very one-sided IP clauses. And to give you an example, sometimes it says that anything that the startup creates, any form of deliverable that the startup creates, vests with the customer, right? Startups don't realize that often they are pretty much giving away what they are creating and not retaining IP. In essence, this also restricts them from using that IP for other customers or for further development internally and going forward. Um, they don't often realize this. It could violate in a not having title to it, and then if you use it again, you are breaching the contract. So it's very important to in contracts to have robust IP clauses. Now, when I say robust, I also mean balanced IP clauses. For instance, there's something known as pre-intellectual property or pre-IP, right? Which is something which is inherent in the startup, which they already have, which is proprietary to them in the form of a computer program or in the form of certain material, written material, or other type of content which they already have. Now, it's important to keep that IP within the company and not have it assigned to customers or transferred to customers. If they create certain bespoke um, IP or bespoke product offerings for customers, then on a case-to-case basis or basis the commercial understanding, they may assign ownership in the bespoke deliverable to the customer. Um, in terms of record keeping as well, it's important to keep records of all of these things, because especially for copyright is not something you need to go and register, right? So you write down a particular note, which is proprietary. But you don't, the proof of ownership would essentially be the original copy and as and when you created it, right? The date of the email or the Word document. So record keeping becomes extremely important. Um, and I think I'll end with a point on trademark and domain names. Now, often startups, come up with the most interesting brand names and logos. It's important at a first instance to check what is the veracity, what is the tenability of the trademark. Trademark law in India doesn't allow you to register every trademark. Now, I would address this in two cases. It's important to know that none of your competitors, no other person in the market is using a similar trademark. You don't want to go and infringe somebody else's brand or somebody else's trademark. So it would be good to be prudent to do a trademark search. So the IP office, the trademark office has a website. Do a search, see if a particular trademark, a brand name is already being used by another company, and then do it accordingly. Secondly, there are certain grounds for registration, right? For example, a trademark has to be it need not be descriptive of the goods, and it can be denied or not being distinct enough, right? So you want to just check first, what are your chances of getting that trademark or brand name registered, in order to have that. And also, obviously, once you do that, make your filings to register for your trademark. That is important. And lastly, on the domain name, I'll spend barely 10 seconds. Domain name is very, very important. It's the core to the business, because if users cannot go to your URL or go to your website, it's a big loss, right? In traction with users and revenue loss. So you want to ensure that your domain name is registered. Particularly the owner of the domain name, you want it to be the registrant organization. You want it to be the company name. You don't want it to be an employee, because an employee may move on. You don't want it to be a third party that may have handled the domain name registration for you. You want it to be in the name of the company. And I think, with that, I'll end and happy to address questions at the end.
So, Aaron, just before you leave, here, I think the other question that keeps coming to the minds of a lot of founders is, how do you protect an idea essentially in India? Is there an IP which can protect my idea? If I have an idea, I'm sitting on one. I can't go for a trademark. I can't go for a copyright. So what do I do? How do I protect my idea, which I'm essentially diverging to a lot of my investors or advisors? So how do I do that?
Good question. An idea by itself cannot be protected under IP laws in India. IP laws, especially copyright, I'll talk about copyright because copyright aims to protect ideas, but it does not protect merely an idea, right? So if I'm sitting on, if I have, a sudden brave wave or an idea in my mind, I can't get copyright protection. What IP protection I get is the expression of my idea, right? How I express it. That form is given IP protection. So I saw one of the questions was that, say you create a marketing pitch, you create a marketing deck. Now it is useful in the, or say you create emails with proposals, right? This is important where you want to say, you want to put a copyright logo and you want to say copyright and put your company name. You want to ascertain your ownership on that document, right? That you have the copyright, put the date on which you created. And one more thing is what I said is keep records. It's very important tomorrow if there's a dispute to show who created that particular pitch or sales deck or marketing deck and when it was created, and you should be able to show the court or show any authority those records. And the third step is more of a protective step. You can put a disclaimer saying that this is property of the startup and created by us. This cannot be used by you or shared by you in any means. This is our IP. So a good measure would always be a particular disclaimer clarifying ownership.
Okay, so that was helpful, and I think as Aaron mentioned, we'll take up some interesting questions, depending on the time that we have at hand towards the end. From here on, Jaideep, we know that presently the Indian Information Technology Act, prescribes the rules for processing, dealing, and handling sensitive personal data. It also prescribes provisions for compensation for failure to protect the handling of the personal data. In addition, the disclosure of personal information and breach of a lawful contract also we understand is punishable with fine or imprisonment or both. Now, since startups mostly handle a good amount of personal and sensitive personal data, it is essential that they comply with the provisions of the IT Act along with any other sectoral law that may apply to them. We understand that the draft Personal Protection Bill 2018 was released I would not say recently, but in the recent times. And the draft bill mandates several additional obligations for entities engaged in the processing of personal data and is expected to increase the cost of compliance substantially. So, Jaideep, if you could throw some light on what is this new proposal under the, for a new privacy law, and how is it going to impact the startups? And also if you could throw a little bit of light on what has been NDA's contribution in terms of making submissions to the government around it.
Sure, definitely. So, in fact, after the draft bill, that bill came to be introduced in Parliament in the winter session, and it was expected that a committee to which the bill was referred would come up with its report soon. But due to COVID, that has been delayed. But as you said, the entire regime under the IT Act for data protection is going to be overhauled by this new bill. It's called the Personal Data Protection Bill. And what it looks to govern is essentially personal data, again, which is information capable of identifying an individual. It also has certain other incidental provisions, but the focus of it is on personal data. It is definitely going to be a huge change in the entire way a startup or any other tech company looks at data protection compliance and data protection obligations in general, because the current regime is largely a check the box regime, fortunately or unfortunately. And by putting a privacy policy in place and maybe an information security policy and following a few other basic hygiene steps, one can be in compliance with today's law. But the upcoming law is not so straightforward. Those of you who have customers in Europe would have already taken some steps to comply with the GDPR, and which is the European General Data Protection Regulation. And the Personal Data Protection Bill, while it has points or it has a different outlook on several points, in terms of the scale of compliance and the scale of the paradigm shift is quite similar to that. So if anyone has gone through that process for Europe, one advantage is you are somewhat ready for the new Indian the personal data protection bill, but there would be various tweaks, and they would not necessarily always just be check the box tweaks. A startup has to take a complete relook at the way it processes data under the new bill. So, coming to some of the principles that the bill follows, one of the key principles that it follows, or some of the key principles, are largely in line with global standards, including California, which recently introduced a law, and Europe. So it is largely consent based. There is purpose limitation, storage limitation, and data. So interestingly, just to link back to what the Unicreate founders were saying, um, the less personal data you process or collect, the better off you are in terms of legal compliance. Now, I know that inherently in several business models that's not possible, but that is what it comes down to from a legal perspective. To the extent you have to collect data or you have data analytics models you want to run, one has to dig into the weeds and make sure they're compliant. Some of the immediate, very tangible, big ticket items that leap out from the bill is data localization for certain kinds of data. So something called critical personal data, which is as yet not defined, will have to be stored only in India. And sensitive personal data, which is a broader category of information than what is currently considered sensitive. All of those categories of personal data will have to be stored in India, but may be transferred outside India. And the conditions for transfer outside India of sensitive personal data is again similar to what you have under something like the GDPR or even the previous European data protection regulation, you will have to have explicit consent, and then in addition to that, you will have to have a approved contract by the regulator or an intra-group scheme for the transfer. Or you will have to have a transferee entity who's approved by the regulator. So as opposed to today's law, where you can just consent and transfer it outside, under the new law, there will be it becomes a regulated activity. Fortunately, many startups may not get covered under something that's called significant data fiduciary, which has a much higher level of obligation, has to get registered, etc. But on the whole, the bill treats startups and non-startups alike. So that's something that one has to consider. And one thing that one has to keep in mind is that the authorities under the bill, which is the central government and the new data protection regulator, have a lot of rule-making powers. And if you've been dealing with the Companies Act, as I'm sure many of you have who have incorporated companies, every few days or weeks there are new rules, there are amendments. So it's possible that that kind of scheme will again come in through this bill. And what we would say is the startups have to be participative in this process. Just to take an example, under the current data protection rules, there is a provision for an industry body to come together and propose a self-regulation for information security. But to our knowledge, no such standard has been proposed for various reasons. But under the new data protection law, where it becomes much more onerous, the obligations, of course, it's good for the individual. So you'll obviously be wearing two hats. You'll want your data to be processed safe, and you're also a business owner, so you have the compliance obligations. But as far as that goes, to keep in mind that it's good to be participative. So whether you're a member of, say, TIE or NASCOM or IAMAI or any other industry body, it would be good to make your views heard and try and shape the law to what is in line with the industry reality. I won't go on for too much longer on this, but happy to take any questions on this.
Sure. Thanks, Jaydeep. Aaron, would you like to take some of these questions, or while you delve on it, I'll take up some two of the transactional questions.
So I think one of the last questions I'm seeing is that, and I'll scroll up, but if you're developing software for a customer, and if the customer is insisting on owning the IP, what do you do? Because you want to use that IP going forward for your other customers, right? And this is a classic example. The customer, always they feel they're in the bigger shoes, and they're paying, so they want to own whatever they get, but that need not always be the case in IP, right? In this case, what you can do is you can, if you're creating something specific for them and something customized to their needs, you can look at transferring or assigning that IP to them. If you don't feel you need to use it in the future, or if you don't want to use it in the future, and accordingly the purchase price and the consideration would differ. Alternatively, you can follow a licensing model. So you develop the software and you make certain modifications for the customer, basis their requirements, and you license it to them. So in that case, the startup, you continue to retain ownership. Only a license is granted to them for the term of the contract. And the startup, you can also use the IP going forward in future engagements because you have ownership over it. I'm just seeing if there are any other questions here. I think there was one on if somebody creates software which is similar. I think if I got the question correct. Now, see, this is a test of IP infringement, right? This you can apply to any form of IP. On a particular film, infringing another film; on a particular book, infringing another book; a song, infringing another song, and similarly, it's software, in infringing another software. The test, really is it substantially copied? And is there such little effort made by the other person that nothing new is really created? Is it more or less an artificial copy of the same work which does the same thing and conveys the same idea? I think that is the short test whether you're looking at any form of IP, as I mentioned. So you can't really say whether it's 80% or 100%. You can't do that. Courts have looked at it on a substantial similarity test, and whether something new is actually created or whether it's pretty much a copy and does the same thing. Ashita, do you see any other questions on IP, or should we move on?
Yeah, I'll take up actually a few questions, and I think just to add on to Aaron's last point on on a co-developer or somebody who's trying to copy the same idea or the same IP. Now we've also seen cases, and it's important that you also consider them before you document it properly. So we've also seen cases where there is a multiple founder company, and each of the tomorrow there's a rift between the founders. Each founder or the different founders claim an ownership of the IP which is right now vesting in the company. So it's important then that besides having the IP being registered, etc., you also have a very strong co-founders agreement which correctly records and accurately captures the fact that who created the IP and who would the IP be in case there is a rift, etc. So that tomorrow if there is and there have been multiple number of cases in the market where the founders have parted ways, for reasons good or bad. So just be careful when you're documenting between in a co-founder situation on whose IP is it essentially. To take up the other question on, so I think I did try to answer it on the chat window. So in case of slum sale of business, is it necessary to have a separate agreement for assignment of IP? No, it's not necessary to have a separate agreement so long as you have detailed clauses on IP assignment in your business transfer agreement. However, in case you're having a separate IP assignment agreement, don't forget to to stamp and value it appropriately. The other is, the other question I would like to take before I pass it to Jaideep, is that you can have the IP assignment clauses. Sorry, my bad. Several startups register their IP in the name of the founders instead of the startup to save money. So, what is the risk involved in such practices? So I think one of the biggest risk that we see, and I would say less of a risk, more of a cleanup that will essentially happen when an investor selects you for an investment. Right before the investment, the investor is going to ask you to transfer all that IP in the name of the company. Because essentially when they're putting in the money, they're betting on the IP and the entity, and not and so none of these IP will essentially like that they continue to be in the name of the founders. So all of them will need to be transferred. So the sooner the better. And if you can, start from the scratch and get it in the name of the company, it would be that's how it is advisable. Jaideep, do you want to pick on any questions?
Yeah, I think one by Priyanka Dikshit on the restriction third party. So this is quite interesting because I think where you're coming from is you don't have the direct relationship with the individual. So how do you do something like a privacy policy, etc.? The ministry clarified in 2011, that is the Ministry of Electronics and Information Technology, that under the current data protection rules, certain obligations related to collection and disclosure don't apply where you're processing data under a lawful obligation with a third party. Now, the question arises as to when you're purchasing that data, what are the obligations? Now, you don't have the interface with the individual, but in the ministry's clarification, they don't say that you needn't have a privacy policy. Policy element is required. The information required, and transfer outside to another entity. Some of those obligations. Basically, and this is a larger point, we haven't seen much enforcement of the current data protection rules, possibly because there's so many online businesses and it's so hard to track the compliance, and there is no designated regulator to look at it. But under the new data protection bill, there is a designated regulator. There's a lot more awareness of data protection, and the obligations don't fall away just because you purchased it from a third party. So as soon as you've collected information which is personal in nature, even if it's not It also says that you will have to try and find a way to give notice to the individual if you haven't collected from them. So less personal information, the better, because I know you may need these lists for marketing, etc. But to the extent you can work on anonymized data, say for data analytics purposes, etc., like a lot of startups might want to, that shirks off much of the compliance. But to put it short, just because you purchase from a third party doesn't mean that you're home scot-free.
Thanks, Jaideep. Aaron, I'm back to you again with some basic questions, and it would be the back of your head in terms of one of the questions. It says, do you need to register the copyright like you register trademarks?
You can register copyright. You don't need to. You are afforded copyright protection upon creation of the work, and that is what makes copyright unique. So as in when you write something down or develop something or code something, upon creation of that particular work, you get copyright protection. On the other hand, for example, trademarks, you do get some kind of protection using a brand and all of that, but you should go for a trademark registration because your statutory rights are much better. So if you leave it to me, copyright, you don't have to register. Trademark, it is better to register.
Again, Aaron, a follow-on question. For a company which is trying to protect an IoT-based program, should protection be secure under copyright or patent or both?
An IoT-based program, is a software. If it's purely a software program, it would be copyright. If the IoT program, if it not merely interacts with hardware but actually controls hardware, for example, in the EU, their test is different. It has to interact with the hardware for it to get a patent. So if it's similar, then you can do that in India. But the interaction between the software and the hardware, the test is quite high in India. So that needs to be met for it to be patented. Otherwise, copyright.
The next one, Aaron, sorry, there's a lineup for you. I think all of them on patents and trademarks and copyrights. So are patents filed in India protected internationally? Is filing required in multiple geographies?
Okay, so patents and trademarks are both territorial. They are both country-wise. What happens is for ease of filing registrations, you have certain protocols. You have the Madrid protocol, for instance, where you file one application. The base country is India, but it gets applied for in multiple countries, which have signed up to the protocol. So you don't need to make multiple applications in that case. But generally, it is a territorial one. So, for example, in one country, if there already happens to be somebody with a similar patent or a similar trademark, it's very unlikely you'll get protection in that particular country.
I think the last one for you, Aaron, because we are now running out of time, is license to use different from license to own?
So there's no, I wouldn't say there's, yeah, Sudhakaran, thank you. A license to use is generally what we call a license in the first place. You are merely permitting somebody to use it, authorizing somebody to use it. License to own is sort of an oxymoron, if you ask me. There's no, at least in law, there is no concept of license to own. You are either transferring or assigning ownership, more like a purchase or a transfer, where ownership gets assigned, or like I said, it's a license where you are merely permitting somebody to use. I mean, one you would call a sale, another one you would call a license or a permission to use.
Yeah, Jaideep, there is one question on data sovereignty versus data localization. Would you want to pick that up?
Need to find that. Could you tell me a time that was asked?
Okay, so it's I'll just repeat the question. It just says, can you explain what's the difference between data sovereignty versus data localization, and how do companies identify nationality of the personal data?
Sure. So I think that some quarters have been probably trying to draw a distinction between data sovereignty and data localization, saying that if it's our residents' data or citizens' data, we should have some control over it. It need not be localization, which the data needs to be localized. Nationality of personal data, I guess the closest way to come to it is personal data is always linked to a particular individual. So residents or citizenship determine that. But as far as the even the current data protection rules go, there is no distinction that compliance is not required, even if it's a foreign individual's data. But under the new data protection bill, it's been made clear that the bill the act once the bill becomes an act will apply extraterritorially. So given certain nexus requirements, it will apply to entities. Also applies extraterritorially. I got a question one-on-one from the storage. Currently, there's no storage. There's no on data in the data protection rules that everything should be linked to the purpose. And then you have requirements under other laws. For example, under tax laws, you may want to store some relevant data for up to 7 years. But currently, it's purpose linked. But under the new law, it's expressly purpose linked. So there is a clear embargo that you should not process, and process includes storage data for something other than a lawful purpose or longer than is necessary. So, and given that there's a regulator, there checks. So, under the new law, that becomes more relevant. As of now, it's a little open to other practices.
Sure. I think we tried to answer as many questions as we could. If there's anything that still remains, we'll probably get in touch with the attendees offline. Rakesh and Kiran, would you want to make any closing remarks? Any learnings that you would want to share with the audience in a quick snapshot?
Yeah, I think a lot of points which were covered is something that we have faced in our journey, and GDPR became one of the primary things that we had to also look at. Even though we don't have access to that data, our clients need to be able to protect that, and that is where we had to make major architectural change in the product to be able to have traceability of the data and allow easy pseudonymization or anonymization of the data. And that is one of the major things that we've had to handle in terms of protecting the data itself. I think that was one of the bigger learnings from the GDPR.
Sure. I think with that, we would like to close the session. Thank you everyone for joining in. If there's anything, you can write to us on the emails provided, and we'll get back to you. Thank you everybody, and thank you UniCreate team for joining us for the panel today. It was indeed insightful.